All right, welcome to Senate Judiciary. We have a couple of bills today that we're going to take up. House Bill 83, House Bill 102, and then House Bill 178. With that, Pierre, will you please go ahead and call the roll?
Senator Crago.
Here.
Senator Crum. Senator Hicks.
Excused.
Senator Kolb.
Present.
Chairman Olson.
Here.
You have a quorum.
All right. Committee, the first bill for our consideration is House Bill 83, Legislative Subpoena Penalty. I serve on the Management Audit Committee, so I told the chairman that I would introduce this bill to you all. It's really very simple. This bill goes into existing statute 28-1-110, and it amends the penalty for a violation of a legislative subpoena from a $100 fine to a $750 fine. The penalty already exists that, there's already a 6-month potential for the penalty in county jail. That doesn't change. That's still there, but the language that we typically have in our criminal code is, or both. You could be fined and sentenced. And for whatever reason, that was missing from this statute. So we cleaned that up when we made this change to $750. And I will take any questions, committee.
Mr. Chairman,
Senator Craig.
was there any discussion about possibly making that a steeper penalty, like felony level, if we're not going to show up?
Senator Crago, there was a lot of discussion about obviously making it a steeper penalty in general, which is why they raised the fine, but I don't recall a felony conversation. What is the, if I were to be subpoenaed by a court in a civil action and I didn't appear, what would be the penalty? It would just be up to the judge.
I actually think that's a misdemeanor as well. I just was curious if the conversation was had, Mr. Chairman, and why we're going to all this work to just up the fine amount. I mean, this rarely gets used, so I just was curious.
Yeah,
I understand it's ongoing right at the moment, but neither you nor I probably can ever remember it happening in the recent history. So I just was curious about that, something maybe to think about, or if that's a steep enough penalty. I mean, as you and I both know, the difference, but all we're talking is a difference in fine from 100 to 750. That's not really going to create any additional incentive to comply. It just isn't. People will show up, plead guilty to the misdemeanor and move on.
Well, Senator Crago, if this committee wanted to make it a felony, we could definitely have that discussion on the floor. Senator Kolb.
Yeah, thank you, Mr. Chairman. I think it actually should be a felony in this case because that amount of money is really not going to, I think, change anything when it comes to compliance. And it doesn't happen very often, but when it happens, I think people need to comply because it's, because of the rarity of it, actually. So I would be in favor of upping it to a felony.
Okay. Any other questions about this legislation before I go to public comment? And then we can obviously discuss that as a motion when the bill comes back to us. No? Okay. Do I have any agencies wishing to testify on this bill? Is there anyone signed up online agency-wise? No? Any testimony in the room on House Bill 83? I really thought everyone showed up for House Bill 83, so I'm a little taken back. All right, I will close public comment. Committee, what is your pleasure? It's been moved by Senator Crum and seconded by Senator Kolb. And then would you like to make an amendment, Senator Kolb?
Well, I thank you for that positive suggestion, Mr. Chairman. I would like an amendment that we change this to a felony, and then the appropriate fine. I'll let my lawyer type members decide on what's appropriate fine for that, but I think it needs to be a felony and not a misdemeanor.
Do you have an idea of the
Maybe
the
1,000,
incarceration,
up
time?
to a year.
1 year?
Yeah, but that would be a standard that I've seen for something like this. I guess that's open for debate, but let's propose it at 1 year, up to 1 year.
Yeah, I don't know what would be standard in this scenario. But you could definitely do 1 year.
1 year and $1,000 fine. Just change the fine. Once again, that's a debatable number.
Okay, it's been moved. Is there a second?
Second.
Seconded by Senator Craigo. I think we would also have to adjust the language because for whatever reason, this statute says imprisonment in a county jail. So it's very specific on where you would serve. And if you were serving a felony for a year, you might end up going to the state pen. Or what, is that right?
That's correct.
Senator Craigo? Okay. So maybe amend your motion to strike that language, imprisonment in county jail.
That's the motion I meant to make. Yes. Mr.
Yes.
Chairman.
Okay. Second likes that motion.
I do.
Okay. Any discussion on 1 year, $1,000? Everybody feel good about that? Yep. Okay. All those in favor signify by saying aye.
Aye.
Any opposed? All right, that motion has been adopted. Any other amendments or discussion on this bill? All right. Here, will you please do a roll call vote on House Bill 83?
This is a roll call vote on House Bill 83 as amended. Senator Craigo,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Excused.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
Great. Next bill for our consideration is House Bill 102, protecting kids from deepfakes and exploitive images. Representative Lean.
Thank you, Mr. Chairman. Online, I do have a professional witness with me, Tyler Schwab from Libertas International. He was traveling late last night and didn't get the link until today. So I just wanted you to know he's there and ask if he could also testify with me.
We'll take your testimony and then we'll move into public testimony. And if we go to online testimony, then we'll grab him then. What's his name?
Tyler Schwab.
Okay. And you don't, if you know the amendments that were made by the House, when you get to that, if you could just point those out to us, that would be helpful. All right, Representative Lean, go ahead.
Thank you, Mr. Chairman. In Wyoming, we cherish our freedoms and our families, our frontier spirit, and we cannot stand by as AI deepfakes are shattering lives. This bill is our shield. It's protecting children from exploitation, safeguarding privacy, and preserving free speech in this digital age. This bill protects political speech from AI-driven censorship, interactive platforms. It protects privacy and dignity of individuals from non-consensual synthetic sexual materials. It protects children from sexually exploitive AI-generated child pornography. It also outlaws AI-generated child pornography. Some of the harms that this bill takes up is child sex abuse materials and how realistic images of individuals are being transmitted today and regenerated over and over again so that our likeness is being used and it can be damaging to our persons. This bill helps to ban non-consensual deepfakes that invade privacy and extort victims. It prohibits platforms using AI to censor political speech, upholding our freedom of expression under Article 1, Section 20 of the Wyoming Constitution. The amendment that was made in this bill was to take the services providers that provide our internet or satellite to our homes and make sure that they are not being held captive if there is child pornography being sent over their airwaves or their bandwidth or their, I'm sorry, I don't know the proper terms, but that's the amendment that went into the bill. The rest of the bill was original as written. And I can walk through it page by page, or I can take any questions from the committee. But overall, that's what it does.
Overview of the legislation. It has been a while since I read it.
Yes, so here we are sitting at the, I'm just on page 1, and it gives you an overview of what it does. It takes into account criminal offenses for synthetic sexual material using AI against children or against your own likeness. Say this is for your wife, your spouse, your child, your grandchild, that you can protect them as well. It's protecting our most personal private property rights of our own images. It provides immunity for developers of artificial intelligence systems, and it specifies penalties, providing amendments and definitions. In the, I do want to go to the back of the bill to the child exploitation laws, just where we add, so I'm on page 14, 64303. And then on to page 15, we don't change that statute. We're just adding to it that AI generated systems generate or create child pornography or possesses child pornography of a person that knows was generated by an AI system. So we're just adding to the child exploitation laws. We're not changing them or taking away from them. That's one key piece of this that I think is important. And then it does make it a felony, and it follows in line with current crimes of child pornography. I didn't change those, enhance them, or take them away.
Very good. Anything else you want us to know about this bill?
I just ask for your favorable consideration so that we can help protect our children and our own likeness moving forward in this AI tech-driven world.
Representative Lean, on page 2, subsection B, this section is meant to be a general exclusion of developers. Below in subsection C, there's some instances where a developer does not have immunity, but it seems to be at least one of the objects of the legislation is really not to go after the developer unless they, with intent, knew what they were developing and did it for a nefarious purpose. Would you agree with that?
Yes, sir.
Okay, because I think we're going to hear from some developers or people who represent developers that may they've proposed an amendment to me, and I think the purpose is just to make it very clear for the protection for developers. So I just wanted to make sure that was your intent as well.
And I am not, Mr. Chairman, I have not been aware of that amendment. I'd be happy to review it, but that is the intent, is not to take up the developer. I would caution that there are different AI large language models out there that you can take pieces of and start building your own models. And if someone was to build a bot that was just going to be directed at building child pornography or child sex abuse materials, that I would want that to be captured in this legislation, but that an overall AI generating model should not be swept up in this.
Yeah, I think I think there's some protection built in where they have to know or have intent to do something illicit. But I think some of the language that might be problematic is on page 3, Romanet 2. There's this language that says that they should have known that the primary use of the system would be illegal or illicit. And that's a pretty broad statement. I think there's going to be some discussion on that, but I think the goal might be to take out the language should have known. I think it's a little problematic, and I don't know that captures any more bad actors, but that has the potential to capture good actors in the law unintentionally. Do you have any thoughts on that, or?
I am open to that being an amendment made to the bill.
Okay, perfect. Any other questions for Representative Lean? Senator Crum, go ahead.
Yes, Mr. Chairman, and for Representative Lynn. I appreciate this bill. My one question is, so the title of the bill says protecting kids. It looks to me when I read the bill, this protects everybody. It's broader than just kids. Am I reading that right or not?
Representative Lean.
Mr. Chairman, Senator Crum, it's predominantly geared towards taking child pornography off of AI child generation, but it does apply to everyone. And so I'm open to an amendment to the title if you want it to be protecting Wyomingites that or persons or, but yes, it does apply broader than just children.
Any other questions for Representative Lee? All right,
Thank you.
thank you. And you have Mr. Schwab
Yeah.
that will have some, that testimony makes sense to bring in right now. So let's go ahead and let Mr. Schwab in. Is this, I can't remember, I probably asked you this question, Representative Lean, but this legislation is modeled after what, which state, or is it a model act?
Yes, sir. Montana does have very similar legislation and the bulk of this did come from there.
Do you know when Montana passed this legislation?
I do not recall the exact date, but I'd be happy to get it and send it
Okay.
to the committee.
Yeah, that'd be great.
Mr. Chairman,
Yes.
Mr. Schwab has declined. He promoted.
Oh, okay. Well, he doesn't want to talk to us. All right, Mr. Schwab, if you did that by accident and you want to come into the room, just raise your hand and then we'll get you in at the appropriate time. Otherwise, we'll go ahead and move into public comment. Are there any agencies wishing to testify on this bill? Were there any agencies online here? Okay, we'll go into general public comment. Is there any public comment on this bill?
Mr. Chairman, members of the committee, my name's Jeff Darty. I'm here today on behalf of Cicero Action. And I really appreciate you giving me just a moment. I'm going to be brief on this. In answer to the question, Mr. Chairman, that you just posed, that passed in Montana last year, if that's helpful to you. So members of the committee,
Yeah,
excuse me?
Mr. Doherty, sorry, just on that note, what I was trying to figure out was how, I wanted to know how long it had been in effect to know if there were any challenges to the language. It's probably too new to know that, but do you know if are there any court cases out of Montana dealing with the legislation?
If you'll give me a second, I'll check, and then perhaps if I get anything, you could call me back up to answer that question. Would
That's-
that be acceptable?
That's
Mr. Chair?
fair.
Okay, fair enough.
Go ahead.
So with that said, I appreciate the opportunity to be here. I'm actually, as I said in the House Committee, I'm actually simultaneously furious and delighted to be here. Furious because I never understood that AI could be used for these purposes. For me, it was just a fantastic tool to review Senate files and House bills and try to understand them better. But as I was doing some research on this in preparation for my comments, I found out that 1.2 million kiddos a year are impacted by this sort of deep fake image generation. And this is a $1.5 billion a year enterprise. And I just don't understand how people's minds work like this. But this bill is an important step in closing those loopholes and getting some serious teeth in terms of prison time in this. One other point of research that I'd bring to the committee's attention, I found one study that actually had people who had problems with pornography who talked about when they see this sort of content, it makes about 50 to 55% of these people worry that they're going to move from just viewing, being a spectator, into what they call hands-on action. And so this is a serious threat that it's vital that we deal with in this session. So, Mr. Chairman, where escalation pathways exist like this, extreme content, it's important that this committee act on this bill. So with that, I'm going to stop my comments there and take any questions and try to answer your question in a moment.
Committee, any questions?
Thank you.
All right, thank you. Yes,
Mr. Schwab is back on,
does he want to come in? Okay,
and Ms. Callis from the Wyoming. County Prosecuting Attorneys Association. Also,
Okay.
that's what that is.
Yeah, let Ms. Callis in.
Ms. Callis and Mr. Schwartz.
Welcome, Ms. Callis.
Good afternoon, Chairman Olson. I'm trying to do double duties. I have the House appropriations open on a different window, so I apologize for my cell phone appearance.
Oh, you don't want to listen to that committee. You tuned into the right committee. Do you have some comments or a position on House Bill 102?
I do, and substantially, I would note that there is split views from the County Attorneys Association on support of this bill, primarily because there is concern related to some of the language and the constitutionality of that. Certainly that will be addressed eventually through the process regardless. Also, independently, I did communicate or send an email to the two sponsors of this bill. Unfortunately, I know that they've been very busy, so they have not been able to respond to me. But I do have concerns with two primary sections of this bill, and that is 64307, which provides for unlawful distribution of non-consensual synthetic sexual material. It's a criminal matter for that. And then later in 64303, it provides for additional provisions as to where artificial intelligence systems can create child sexual assault material, which are statutes all refer to as child pornography still, which is somewhat of an outdated reference. The reason for my concerns for that is because the original definition for child pornography in subsection A2 includes computer generated images. And I currently do have prosecutions in relation to AI material that have already been charged. Specifically, I won't go into detail about the graphicness of the image, but essentially there is a pending case, which I should not comment on specifically other than to note that it involves a child of the defendant where he is alleged to have used artificial intelligence to unclothe her so that it has become now a lascivious display of her genitalia. And so my concern in relation to these two statutes is that it will facilitate, in my opinion, argument to the Supreme Court, first and foremost, that the statute that's currently in place does not contemplate AI generated images, which would negate our prosecution for those offenses. And also that is in both sections. And the 64307 has different penalties than child pornography, even though it contemplates the exact, or it would appear to be the exact same type of crime. So the duplicity of those offenses is also a concern. And so it is my request as the UNT County Attorney that if this moves forward, which again, there's split support in the association, that those provisions of the statute are removed.
So Ms. Callis, give me the page numbers. The first, I know I flagged 6-4-307, but give me the
Let
page
me
number.
pull up the engrossed, sorry, your Chairman Olson. So on the engrossed bill, 64307 starts on page 3 at line 19 and continues through page 6, line 22.
Okay.
And then 64303, the included definitions start on and I should note, I don't have any objection and I can't imagine an objection to the inclusions that are included on page 15, line 19. I think that just goes into more detail to include what images are.
Yeah.
Whereas on page 16, lines 4 through 8, is duplicative of the definition of a computer-generated image and could cause a conflict in interpretation and application to that statute.
Got it. Okay,
And that's those two definitions on 4 through 8 were on page 16. I think I said that.
yes, yeah, I got that. All right, any questions for Ms. Callis, for the Prosecutors Association? All right, we appreciate you tuning in and do appreciate your input.
Thank you, Chairman Allison.
Pierre, have we technical difficulties on his end? Okay,
Mr. Chairman, could I put my phone to the mic? Is that acceptable?
I just have him call in. I mean, I don't, can he not just call into the Zoom?
I'm trying to find the number.
Oh, okay. I'm pretty anti online testimony, and this is a good example of why. I prefer that people are here in person, and I usually give deference to the room because people who have traveled here and committed to the time to be here, that means a lot to me as a committee member that you're here in person, and I just don't like dealing with all the technical difficulties. So, was there any other public testimony online from TechNet? Can we let him in?
If you don't mind, I can introduce Mr. Wood, if that's okay.
Yes, go ahead, Mr. Kidd.
Thank you, Mr. Chairman, members of the committee. My name is Sam Kidd. I work with Holland at Heart. We represent Meta. And to the chairman's point earlier about some of the language in this bill potentially creating problems for developers that are not intentionally trying to create or distribute this kind of material. And I think Mr. Wood can go into more detail. He's provided a letter to the committee members regarding some of the changes that TechNet has proposed and that Meta would also support. And with those amendments, Meta would not be in opposition to this bill. And I'll let Mr. Wood take over, and I can help answer questions as well.
So, Mr. Wood, just what would be helpful is, I'm very interested in. Sorry, my mic wasn't lit. Mr. Wood, what would be helpful is that I'm very interested in the amendment in particular. I understand when I look at the proposed amendment, the should have known language throughout the bill. I understand those deletions and have no issue with that. But the amendment that you're proposing to us does also have a pretty substantial deletion. And that is the page 11, 12, and 13, where you are asking us to delete an entire article, Article 8. So I would like a lot more explanation on that, if you would, please.
Yes, absolutely. I can target my comments to that. And thank you, Chair Olson and members of the committee. Thank you for the opportunity to testify virtually on this bill. I apologize for being virtual. My name is Andrew Wood. I'm the Executive Director for TechNet's Central Region. TechNet's a national bipartisan network of technology CEOs and senior executives that promotes the growth in the innovation economy. Skipping down about those first two amendment requests as it relates to the should have known negligence standard, turning to my next point, Section 40-12-801, which I believe is Section 8 in the bill, it prohibits platforms from using AI to moderate political speech. And the issue here, Chair, is that the Supreme Court has addressed a nearly identical provision in Moody versus Net Choice last year and found that to be unconstitutional. And that provision does not advance the bill's child safety purpose, which we do support. And so we ask that that section be struck from the bill just to avoid that litigation risk and any cost to the state as it relates from that. I also just want to say something else. I want to acknowledge something positive. The engrossed version of the bill is amended by the House. It already includes some intermediary liability protections that we had sought in the House committee. We commend the House for adopting those amendments, and we urge this committee to preserve those as well. And we welcome the opportunity to work with the sponsors and the committee on those targeted amendments. And I'm available for any questions.
All right, I really appreciate you clearing up Article 8 for us. That is helpful. And just let me look real quick. I want to make sure I don't have any other questions about this amendment. All right, Mr. Wood, appreciate that. Are there any questions for Mr. Wood? Okay, thank you.
And
Thank you so much. I'll try to be there in person next time.
Yes, please. We would love to have you in Wyoming. Mr. Kidd.
Mr. Chairman, I just wanted to clarify kind of the location of the changes for, as far as in section 64307 is where the kind of knowingly and intentionally language is missing.
Yeah,
It's present in other similar sections of this bill. And I think if you look at page 4,
line 10.
line 10, I think probably what makes sense, looking at the language of this section B, but also the preceding section A, is removing that or should have known
Mhm.
from line 10.
Yep. Got
And
that.
then adding either knowingly or intentionally or both at the beginning of subsection A on line 4.
Where are you adding that language?
Same page,
Same page, okay.
line 4.
In front of distributes?
Yes, Chairman. That would make it, using the language knowingly, that would make it track fairly closely with 64308. If you see it on page 7, line 11, it starts with knowingly develops or distributes. And then also align with section 64701 on page 9, line 21, where it says knowingly develops or distributes.
So you just want you're asking only for the knowingly language. I thought I heard you say knowingly and intentionally, but
I think either
knowingly is enough by itself.
knowingly would sync it up and make it consistent with the other portions of statute. And then the section that you had mentioned earlier on page 3, lines 4, 5, and 6, that the sponsor agreed, may be willing to remove as well. That would also, taking that portion out and then
There
making
should
it,
have known language on line 5 of page 3.
I think that whole subsection Roman.
Oh, you've got the whole, so yeah.
Right,
Yep.
needs to go. And
Yep.
it would just be a period on line 2 at the end of activities. And that
Okay.
would capture everyone who's knowingly doing this, along with those changes on page 4. That would capture get rid of all the should have knowns out of this felony statute.
Got it. Any questions for Mr. Kidd?
And any questions for me, Mr. Chairman, on the removal of that other section that has the constitutional concerns?
No, that's a perfect answer to why we would not want it in the legislation. I mean, we would not want to, I don't, spend the time to go through kind of line by line and really understand how similar that language was to the language that was challenged in Moody versus net choice. But just as a whole, I think based on the constraints that we have, that's probably sufficient testimony.
Thank you, Mr. Chairman.
Unless the committee has any questions. Okay, thank you. Did we get Mr. Schwab? Mr. Schwab, welcome.
Hi, committee, Mr. Chairman. Can you guys hear me okay?
We sure can.
Well, I just want to extend my apologies for the technological issues. I'm traveling, and so my cell phone, when it's not in Wyoming, decides not to work. So I just want to apologize for that. And then secondly, it's great to see you guys again. It's great to be able to talk about this bill. This bill, it means a lot to me. It means a lot to our nonprofit. I spent the last 13, 14 years working human trafficking, working child crimes across the world, including Wyoming, here in the United States, all over. And it's honestly tough to keep up with technology at times, especially the last couple of years because of AI. AI has a lot of good things about it, but we're also seeing a lot of ways that it can be very damaging to our children and children across the world. We're finding cases of AI generated CSAM, AI generated child pornography. We're finding cases of just recently last week, we had a case where a guy was arrested with CSAM on his phone, with child sex dolls in his house, and then with AI generated CSAM on his phone as well, which he then used to describe as a gateway drug, preparing him to abuse a real child using AI to satisfy the sick fantasies that he has. And I want to talk specifically about a case that's very concerning to me because of the work that I've done. About 12 years ago, we rescued a girl from her mother. The mother had a attraction to pedophiles. She would find pedophiles on Tinder, and she would compete with the pedophile to see who he would have sex with first, essentially, her or her daughter being 6 years old. And she never won. She never won this sick, disgusting game that she had. The guy's in jail. She's in jail as well. But the guy, he abused her. He filmed the abuse, and based on the type of abuse that he enacted on this kid, her abuse went viral. She became famous as essentially a CSAM star on the public web and on the dark web. And those images still circulate based on the folders that he created, based on the situations he created. And now with AI, she's even more at risk because she went viral essentially when she was a child being abused by this man. There's a potential now to where people can use AI to recreate her image and create new CSAM of her in her likeness that can then be spread on the public web and in the dark web. She's grown a lot. She's 21 now. She has her own life. She has her own career. She's moved on in a really amazing way from the abuse that she suffered. And because of AI, because of these predators, because of these guys not just being monsters, but also collectors, she's at risk again that she may be re-abused and re-exploited based on her image and her likeness of what happened to her as a child until the day that she dies. And so this law, like I'm very proud to support it here at Libertas International because it gives Wyoming law enforcement teeth to protect someone like this survivor. It gives them teeth to protect their likeness and their image to where if they have a horrific childhood like this girl had, that if someone recreates her image in a form of artificial intelligence CSAM, artificial intelligence child pornography, she then has the legal tools to hold these people accountable and receive some kind of justice. The justice is not just that she has to live with this still, even being 21, 22 years old, but now she has at least the power of the law behind her to go after the people that would create this. And so for me at Libertas, it's my great honor to stand behind this bill, and I'm really excited that Wyoming has a chance to really have strong teeth in this fight that will only get more and more complicated as AI continues to develop.
Committee, any questions? All right, we're glad you finally got to zoom in with us, and we appreciate your testimony.
Pleasure's mine. Thank you.
Any other public testimony? All right, I will close public testimony on House Bill 102. Committee, what is your pleasure? Senator Cole moves the bill.
I'll second it.
Seconded by
For discussion.
Representative
Clear.
or Senator Crago. I served in the House with Representative Crago, so I know both Representative Crago and Senator Crago, and sometimes I forget. Okay. So one thing for sure, I don't know. Yes, it's been distributed to everybody. So there is this amendment. I would definitely entertain a motion for this amendment. I think we need to address the language that's already been found unconstitutional. And I think the should have known language for the felony provision is very problematic as well. And this amendment addresses both of those issues. It's been moved by Senator Crum
Second.
and seconded by Senator Kolb. Any discussion on this amendment?
Mr. Chairman,
Go ahead, Senator Hicks.
a little discussion, because I would agree with the provision in there that's already covered on that section 8 for Article 8. So we're also going in there and as I look at the amendment, we're deleting 64308, and if I could just get a little more explanation as to why we would do that.
Did you say 64308? No, that's not being deleted with this amendment.
Oh, after that, no, it's, where was that section? I thought we were also deleting 64307.
That's a different.
Okay,
That's
all right, thank you
prosecutors.
for that clarification.
Pierre, the one thing to add, you've got the written amendment, but this amendment should also contain on page 4, line 4, in front of distributes, the word knowingly was part of that amendment. Right?
Mhm. Yeah.
Okay. The mover and the second agree.
Yeah.
Any other discussion on this amendment? All right. All those in favor signify by saying aye. Any opposed? That amendment has been adopted. Senator Craigo, I don't know exactly what to do with the comments from the Prosecutors Association. I mean, as a whole, I wish I had more time to really study the language that they have some issues with and compare it to some existing statute that may have conflict apparently, but I don't have any, I guess. Yeah, I don't know if you have any thoughts, Senator Craigo.
Mr. Chairman, so they have two separate amendments, right? And I think let's talk about the first one first, which starts on page 3, which they asked us to get rid of section 64307.
That's a lot.
It's a lot. And there really isn't much left of the bill if we do that. So I guess I'm not prepared to probably do that here today without some more discussion with them. And so I'm not gonna talk about that one in too much detail, but I think the other
What's the
one
other
does make sense, Mr. Chairman. And so the other one really would be deleting on page 16.
Okay.
From all of page 16 and lines 1 through 7 on page 17. Because so a lot of this is just going in and adding the additional new paragraphs to the penalty provisions. And if we're getting in their concern, and I understand this, their concern that the two new paragraphs on lines 4 through 8 on page 16 are duplicative of language we already have in statute and that we don't need those. I understand their concern about that. And if we don't need those, then we don't need anything else on page 16 or everything above section 3 on page 17.
Because what this is subsection B, a person is guilty of sexual exploitation if the following, we cover that in our statute.
Correct.
I just want to make sure for the public listening that we're sexual exploitation is covered in separate legislation for existing statute.
And I think the existing statute, and I don't have the book in front of me, which we can grab it if we want, but it talks about computer generated child pornography as opposed to AI generated child pornography. And what they're saying is those are one and the same.
So, Mr. Chairman, so we're still good with the going into 64303 on page 15 with those changes, right?
Mr. Chairman.
Senator Craigo.
So the county attorneys, prosecutors said that was fine, that was a good addition. It just makes, adds a couple.
The
things.
film and video.
Yep. They did not seem to have an issue with that. They were just worried that we were creating duplicative language on page 16.
So, Mr. Chairman, under that,
Senator
did we
Hicks.
just eliminate everything on page 16
And 7.
and 7?
Through line 8.
Yeah, through line 8.
Keep section 3.
Yeah.
Okay, so that's been moved by Senator Craigo and seconded by Senator Hicks. Here, you tracking? All right. Any other discussion on this amendment? All those in favor signify by saying aye.
Aye.
Any opposed? All right. Any other, I think that covers all the amendments that we talked about. Are there any other amendments? Committee? Any discussion on this bill?
Well, the bill, Mr. Chairman.
It's already been moved. Senator Colby?
Yeah, thank you, Mr. Chairman. What's been the ruling of the courts on this particular situation with deep fakes when in fact maybe it has a resemblance of somebody? I'm concerned that this hasn't been proven out. I mean, from what I've heard, and you have some attorneys here that have a broader amount of information than I do. Has this gone through the court system? This type of challenge to say that this is, actually a crime for these deep fakes? I just wonder about the breadth of it. I mean, could you just fake and make a synthetic something and then that would be a deep fake because it looks like something else? That's my question, is how far has it gone? Has it been proven? Has the Supreme Court handled this case yet?
Senator Kolb, I don't know if I can perfectly answer your question, but based on the testimony that from Ms. Callis, our statutes already address a computer generated image of a child. And I think what this bill seeks to do is define, in our world we're in now, and as this grows, I'm not sure that AI and a computer generated image are exactly the same thing. I mean, AI is by itself its own creature. And so I think this legislation is attempting to get ahead of the game as AI is quickly developing. So I do firmly believe that there's a gap in our law that doesn't very specifically address artificial intelligence. And I would hate to see a bad actor get away from a heinous crime just because they used AI to generate the image as opposed to doing it themselves in Photoshop or something like that. So I do think this legislation is very necessary. I think AI is emerging so quickly and is so new that I don't think the courts have had the full opportunity to address it, honestly. I think a lot of it's new to them.
Just a comment, I guess we should charge AI pretty soon. That's I think where this is going. But thank you for the explanation, Mr. Chairman.
Any other discussion?
Question.
Are you exploring something? All right, committee. Let's back this up a notch. We're gonna back this up to the last motion, the motion to delete page 16 and page 17, so subsection B, C, D, and E. May be an error. I think we need a little more time to study it. I think it would be probably more prudent based on what what we're reading in our sexual exploitation statute of 6-4-303 that I think this language is okay. So I would my recommendation would be to keep this language and continue the conversation with the Prosecutors Association to make sure we get it right, but I'm not sure we have it right now.
So moved.
So that's a motion to undo a motion.
Second.
All right, it's been moved and seconded. We already had the discussion. All those in favor signify by saying aye.
Aye.
Any opposed? Pierre, that makes sense? You just scratch that out.
Yeah.
Okay.
Just remember plus 8494 except going.
Yes, that should be the only amendment. Okay. Any other discussion on this bill? All right, Pierre, we'll do a roll call vote on House Bill 102.
This is a roll call vote on House Bill 102 as amended. Senator Kriegel.
Aye.
Senator Crum.
Aye.
Senator Hicks.
Aye.
Senator Kolb.
Aye.
Chairman Olson.
Aye.
5 ayes.
All right, that takes us to our last bill. House Bill 178, Public Unions, Transparency and Dues Withdrawal Limitations. This sounds like a judiciary topic to me. Welcome, Representative Williams to Judiciary.
Thank you, Chairman, members of the committee. House Bill 178. It's a worker freedom bill in relation to public sector unions. This bill ensures public employees maintain full control over their own earnings and voluntary associations, and it prevents the state from automatically collecting dues or political contributions on behalf of a union. On page 2 of the bill is the central provision of the bill, which prohibits public employers from using public funds or facilities to deduct union dues. This ends automatic payroll deductions, allowing workers to decide for themselves whether to support unions and requiring any payments be made directly and voluntarily rather than through involuntary withholdings. It's important to note that this legislation does not prevent or stop anyone from voluntary association. If you want to join a union, you're capable of doing so. The only difference is if this bill is enacted, the state will not be involved in that transaction in any way. On page 4, page 3 and 4, all of page 3, and then on to most of the way down page 4, it talks about transparency and accountability area of the bill that requires public employee unions to prepare annual reports, and gives a few details there, including their spending on political activities. And on the bottom of page 4 and on to page 5, it specifies where those reports will need to be shared. And then on page 5, there's a short provision there at D in the middle of the page that deals with unions that file federal form LM2. If they file that with the U.S. Department of Labor, they're exempt from this reporting requirement. On page 6, is where the bill explicitly states it does not authorize new collective bargaining obligations. It does not impair firefighters' bargaining rights under existing law. Does not prohibit employees from making direct voluntary payments. We put an amendment on it in the House that put a belt and suspenders on carve-outs for our firefighters.
Representative Williams, what
Yes.
you're referring to is the language on page 6, lines 18 through 21, specifically tell us that nothing in this bill is meant to impair the right of firefighters to collectively bargain. And then the other language that you're referring to is on page 8. Public employer means the state of Wyoming, city, town, county, political subdivision, etc. Public employers shall not include a public safety agency. And then it cites a statute, and that statute tells us that fire departments are public safety agencies, so they are excluded from this bill.
Yes, Chairman Olson, my understanding is that the public safety agency defined by 92-1101 includes law enforcement and EMS, and the next statute that refers to corporate
firefighters.
authority is firefighters.
That was going to be my follow-up question, was that we're also confident that we've excluded the police, and you said EMS as well?
Yes.
Okay. All right, please proceed.
So House Bill 178 strengthens individual choice and reduces government facilitation of union funding and promotes greater transparency in how union dues are collected and spent. And from my perspective, that's a benefit to public employees in Wyoming. And I'd be happy to stand for questions.
Thank you, Representative Williams. Yes, Senator Hicks, go ahead.
Mr. Chairman, obviously there's some concerns that have happened associated with the way these dues have been collected or paid out to organizations that the members may or may not have been aware of. Could you just give me some examples of that you're aware of where that may have happened?
Representative Williams.
Thank you, Chairman and Senator Hicks. In the last week, I've received many thank yous from constituents who reference what you have, what you've suggested, just that that the dues that they've paid in the past were used to advocate for policy that they were not supportive of. And that's part of the motivation.
So, Mr. Chairman, so their concerns is their dues that they thought they were paying for an organization were being used for political purposes or some other purposes that they found inappropriate for the use of their funds, but they weren't aware of that was going on. There's lack of transparency is their concern. Is that correct?
That is correct.
All right, thank you.
Representative Williams, if you don't know this, I can ask others in the room, but of the unions that we're addressing in this bill, so for example, the Teachers Association is, the WEA is obviously addressed by this legislation. Can you tell me what percentage of teachers in the state of Wyoming are members of the WEA?
I cannot.
Somebody will have that answer, I assume. You probably can't tell me that for any of the firefighters, or do you know any numbers on that?
I do not. I am, my motivation is simply from the worker's point of view and one individual at a time. And so I'm not familiar with those statistics, Chairman.
Okay, I'm just curious is all. Senator Kolb.
Yeah, thank you, Mr. Chairman. Representative, could you, I guess, explain the carve out you have for firefighters? I mean, I guess in totality, why aren't they included with the, for the same lack of ability to say pay automatic dues, or maybe they are? Could you explain that, how that interaction would work and why, if they were carved out, why?
Representative Williams.
Thank you, Chairman Olson, Senator Kolb. The carve out, as I understand it, is from existing statute. It's not in this. This just supports the carve out that's already in statute. And House Bill 178 does not affect current law and firefighters in my my understanding.
Follow up,
please.
Yeah, thank you, Mr. Chairman. Just be more clear. I just wonder why we're not treating people all the same. I don't have any issue. I don't take issue with what you're trying to do with this bill. I'm just concerned, like, why don't we haul them all in and say, why are we doing it for these other areas also? That's my overall concern is, why isn't it more broad? If we have an issue here with this, thing, maybe we can't do that with this bill you have in front of us. But my concern is why didn't we do it or even contemplate the need for it, unless there's something I don't know about this and there is no need for it. So I was trying to understand that nuance of how they interplay between those two different groups. I'm just talking about two groups now, the WEA and the firefighters. Why weren't they treated the same? That frankly, it kind of concerns me that they weren't. Thank you, Mr. Chairman.
Representative Williams.
Chairman Olson, Senator Kolb. Appreciate that. I am confident that there are those in attendance to the meeting
in attendance at our meeting today who can elaborate on the history of that carve out. And I do believe you're correct in stating that this might be a different bill. But thank you very much.
And I'll chime in a little, Senator Kolb. In 1965, we passed a law that enshrined in our statutes collective bargaining for firefighters. It is the only collective bargaining association recognized in Wyoming state law. So we long ago carved out an exception for firefighters. So they have, in their existence, they have never been treated equally to other unions, if you may, or collective bargaining associations. They've always been treated differently by having this elevated position in statute. Senator Kolb.
Well, thank you, Mr. Chairman, for that background information. I'm sure I was a young tyke back then.
I wasn't even a thought.
Well, I was pretty young. The point would be is I just don't know why we're treating people saying this bill doesn't, contemplate that. But I think if it's a statute, we can change that statute. That's what I'll end it on. Thank you.
Okay, Senator Crum.
Thank you, Mr. Chairman. Kind of following that same line of thought. So a question would be, firefighters have collective bargaining. And then we talk about public safety folks in here. I'm concerned about why not everybody's treated all the same here too. And so if it's firefighters, then what about police and EMS and those type of organizations? Shouldn't they then be included in this if they don't have the collective bargaining portion with them? Would be my question. One of my first questions. I got a couple others.
Representative Williams.
Chairman.
Go ahead.
Senator Crum. House Bill 178 really doesn't address those issues. It is just addressing the automatic withdrawal issue.
Mr. Chairman.
Senator Crum.
And that's exactly where I'm at too, is why not address the automatic withdrawal with other public safety organizations, with the exception of firefighters, which have a special carve out.
Representative Williams. Sounds like we may get some public testimony that may help us with that question. So.
And then, Mr. Chairman, another question I have.
Put it out into the ethos.
What's that?
We're going to put it out into the ethos.
Perfect. And this one probably is too, Mr. Chairman, but just wanted to be answered maybe by somebody is, okay, so we've got the collective bargaining on collecting the dues, but we're also talking about political contributions. So can we separate the dues portion for the firefighters where they can go ahead and collect, but then the political contribution piece that's automatically taken out, can we have that apply to everybody across the board?
Do you have any thoughts on that, Representative Williams?
Thank you, Chairman, and thank you, Senator Crum. This bill did not address that in particular. I appreciate that giving me a lot to think about, and we'll no doubt hear a little more here soon, hopefully.
Thank you.
Senator Krieger.
I'm gonna go a simpler direction. Page 5, line 18, Mr. Chairman. Representative Williams, so it says 18 and 19, any person who violates this section shall be guilty of a misdemeanor, but it has no penalty. So is that located somewhere else in the statute? Existing law?
Representative Williams.
My understanding is any person may file a complaint with the Attorney General or the relevant district attorney for investigation and prosecution, but I'm not aware of restate the last.
Do you have it, to throw you a lifeline? The bill does not address it somewhere else that I am familiar with either, but do you have any thoughts on basically what Senator Crago is asking is typically when we say, guilty of a misdemeanor, punishable of a misdemeanor, we will then have a sentencing portion as well. So
included in the
in the
Mr.
legislation,
Chairman?
yeah. So do you have an opinion on, should that be 6 months? Should it be up to a year? Should it be $750 fine or up to $1,000? Do you have any opinions?
Death. Yeah.
Death penalty. We all know my position on that, so.
Yes. No, that, I'm open to having that conversation and open to amendment there.
Okay,
Certainly.
all right. We will take that up. Any other questions for Representative Williams? All right, thank you.
Thank you, committee.
Are there any state agencies wishing to testify on this bill? Were there any state agencies online? Okay. Oh, here we go.
Mr. Chairman, I believe Senator Boner's here to testify. I can wait for
Yes.
him, or do you want me to go?
I will
now?
let me take your testimony and then we'll go to Senator Boner, since you're already there.
All right. Thank you, Mr. Chairman. Committee members, Dickie Shaner here on behalf of State Superintendent Dagenfelder. She supports this bill. It's good policy to untangle the finances of government institutions and labor organizations. And the added transparency around the election activity and legal activity is also helpful, given that this involves government employees and funding. And so with that, Mr. Chairman, that concludes my remarks.
Questions for the superintendent's office? All right. Thank you, Mr. Shaner. Senator Boner. We figured we could hear from you on the floor, so we weren't real eager to get your testimony, but we'll take your testimony.
Yeah, and I don't have much to add, Mr. Chairman, but since you called me up here, support the bill. To be clear, it's an effort to ensure that these organizations are responsive to their members. That's the theme throughout the bill. And I just, want to support it. Know that there's a lot of questions about fairness, and I just reiterate what Representative Williams said. Clearly, that's been a discussion that has occurred previously. I could speculate as to why that is, but this was not really the purpose of the bill to broach that subject. That's probably a broader discussion. And, like I said, we could speculate as to why first responders, emergency service folks, firefighters, folks who are on call 24/7, have a public safety mission are exempt. But I'm, in looking at this bill is kind of outside the scope of what we're trying to achieve here. So that's the best I can answer that. So.
Any questions for Senator Boner? All right. Thank you, Senator. All right. Just want to get a sense. We've got about 50 minutes left. If we decide to work this bill, we'll need some time to work the bill. Just want to get a sense for testimony. If you're planning on testifying on this bill, can you raise your hand?
Wow.
Okay. And so what I'm going to do, and I've got some folks online too, and some of which I talked to in advance of this meeting that told me they would not be able to make it, but would have otherwise been here. So I do want to see if we can get through all of the testimony. I think what I'm going to do, this has been working really well lately, so I like this new method. I'm going to devote 15 minutes to opposition and 15 minutes in favor of this legislation. And then I'm not going to time you individually. So if somebody takes 15 minutes, then they'll have to answer to the rest of you that didn't get to testify. I just feed you to the lions. So and we'll go ahead and take opposition first. So if you want to speak against House Bill 178, please just come up to there's 3 chairs, just fill them up and we'll go from there. And we'll just start on my right. Welcome.
Mr. Chairman, members of the committee, my name is Tate Mullen, Government Relations Director for the Wyoming Education Association. So Wyoming values hard work. The folks that this bill specifically targets are public employees, and our teachers embody that value. In Wyoming, we also value freedom. That value of freedom extends to how these hardworking individuals spend their dollars earned from their labor and the services that they provided. Inversely, we also value the freedom from big government, especially in the form of government telling us how to spend our dollars and where to spend our dollars. I want to be incredibly clear. None of our dues are involuntary. Everybody has to sign up to be a member of the Wyoming Education Association. There are no involuntary dues, and they can be canceled at any time. I will speak to the end of this about the transparency of our organization and how all of our members' voices are taken into account. So this proposal unfairly singles out folks like public employees and teachers, yet allows insurance companies, large special interests, big banks, financial companies, and others to spend heavily on lobbying and politics. Let's get back to the issue of big government. On one hand, it eliminates dues deductions. We are a nonprofit organization. We are not a state entity, but now the proposal is to mandate non-government organizations to provide member info, dollars spent. This is also an embodiment of big government. So we know that the costs incurred to provide dues deduction, it's negligible. What we must look at then are the potential other intents. And we don't need to look much further than what has happened in other states. These bills have been around for a very long time, and the intent is to bust unions and bust associations. This violates the very founding principles which this nation was formed on. In Madison's Federalist Number 10, he discussed factions, that factions were a necessary requirement in a representative republic, and that those factions needed competing interests. This is where we get our checks and balances. Not only do we need our checks and balances within government, but we need those checks and balances within our political organizations, associations, and unions. And we have that. This is an attempt to silence the voices of those factions that some may not like and allow others to continue participating in the political realm. I do want to talk about our members. We are a member-led, member-driven organization. We are run by our membership. Every member has the opportunity to engage in a variety of committees. I'm going to use my role, for example. So as the government relations director, I am bound to our legislative platform. We have members who volunteer, and they're all offered the opportunity to sit on our GR committee, to direct policy, to change our legislative platforms. They have that opportunity to do that, and I am bound by that platform. I cannot advocate for anything outside of that platform. Everybody has that opportunity, every single one of our membership along the way in a variety of capacities. We provide information, we provide updates in terms of what those opportunities look like. We are incredibly transparent with our membership. So with that, I don't want to take up everybody else's time, but there is definitely a significant equal protection issue with the exemption for firefighters. We are conflating collective bargaining with dues deduction. I'm not aware of any government entity, city, town, county, or school district that can negotiate for something that is expressly prohibited in law. So the first part of this bill expressly prohibits the dues deduction. What city, county, or town is going to say, you know, let's negotiate something that is illegal in law? Our negotiations, we have those discussions at the local level with all of our districts. We have those conversations. So the difference being, and to get to your point, Senator Crum, is that what this does is say, so for firefighters, yes, we're still allowing you to collectively bargain. At the same time, it is saying, no, you as the Wyoming Education Association as a local cannot have that conversation or agreement with your school district to provide those dues deduction. That's an equal protection violation. So with that, I'll stand for any questions.
Mr. Mullen, it's my understanding that approximately 8 school districts in the state of Wyoming use the government's payroll system to deduct dues for the Wyoming Education Association. And that's one thing. But what is really troubling to me is that they also deduct dues for or contributions to a PAC. Can you please explain that?
Mr. Chairman, so Our political action committee is a completely separate entity. No dues dollars are used for candidate endorsements from the Wyoming Education Association. That is another opportunity that they have to select into that payment. And they get to choose that. Now, I want to come back to the issue of that allowance for, so we're going to allow for insurance deductions. We're going to allow for a number of these other deductions. We cannot kid ourselves to think that the insurance companies and big financial institutions don't utilize profits to then reinvest them in political activity. So again, we are targeting one specific political voice at the risk of others. So I hope that answers your question in terms of our political contributions.
It does. Thank you. And I'm just curious, what percentage of Wyoming teachers are members of WEA?
Mr. Chairman, I am not at liberty to answer that question.
You can't tell us, or you don't know?
I'm just not at liberty to give that answer. We have a rolling membership, and since I've been here, I have not had the opportunity to look at our updated numbers.
I see. Okay. All right. Any other questions for Mr. Mullen?
Mr. Chairman?
Yes, Senator
Just to
Hicks.
follow up, can you give us an average, wild guess, speculate?
Oh,
10%, 15, or just, you don't know and won't tell?
Mr. Chairman, if I could
Mr. Mullen.
bring my president up here, he's got some information.
He's got some numbers. I've heard numbers before, but never known if they were accurate or not. So if you want to come on up. Got a answer to our question?
Mr. Chairman, members of the committee, my name is Grady Hedgerson. I'm the executive director of the Wyoming Education Association. And we have a membership of over 5,000 members. To answer your question about our membership, I want to frame it this way for you all. The reporting requirements in this bill that we are opposed to is because we're not a public agency.
Okay, so how many teachers are there in the state of Wyoming?
If you're talking about specific classroom teachers or education employees, because
Are all education, I don't know enough about your organization. Are all education employees eligible to be members?
Mr. Chairman, our organization is open to K-12 educators, higher ed, and retired educators.
So I'm just really trying to understand what percentage of educational folks in the state of Wyoming are a member of your organization.
Yeah, so Mr. Chair, the reason I asked that question is because there are classroom teachers, K-12. There are also our education support professionals that are eligible to be members of the Wyoming Education Association. And I'm always nervous to share numbers without having them in front of me. And the department is behind me. They may be able to correct me. I believe statewide there's 17,500 education employees. But I'm not positive of that because I don't have it in front of me. I don't want to give you bad information. And so, like I said,
Apparently you're just not as curious as me because it seems like
we represent over 5,000.
The percentage, I think I would, if I were in your shoes, I would know exactly what that number is, but I know what 5 divided by 17,000 is, I suppose, about
There you go.
30%. So, okay.
Mr. Chairman?
Yes, Senator Crum.
Just a quick follow-up on that. Is there another organization other than WEA in the state that represents education professionals?
Sure.
Mr. Chair, Senator Crum, yes, and I'll turn the mic over.
All right. Any other questions for the executive director? All right. Welcome, ma'am.
Good afternoon, Mr. Chairman and members of the committee. I'm Betty Jo Beardsley. I'm the Executive Director of the Wyoming Public Employees Association. And our organization represents all state employees. And we also represent 3 units of classified employees in Laramie County School District number 1. And that's the only school district we are involved in. And those 3 units are custodial, nutrition services, and then technical support services, which includes like plumbers and painters and secretaries and IT. It's just a variety of all occupations. Our organization was formed in 1962, and it was to allow state employees to have a voice to the legislative body and the executive branch. And over the years, we have been contacted by certain school districts that are classified employees that are not represented by the Wyoming Education Association's group because they were not teachers. But like I said, the only one we have is Laramie County School District number 1. And the state employees do not have collective bargaining. But here's where I'm in a dilemma because, like I said, we represent all state employees. We have firefighters that work for the military department in both Cheyenne and Guernsey. You're now adding positions for firefighters in the, you gotta remember the agency. Fire marshals. Is that the one that the new, there's 5 positions going into, but anyway, you know, and the only reason we are affiliated with a kind of a labor union, we are affiliated with the Service Employees International Union, which is a national union. And the reason we are affiliated with them is, as you all know, Wyoming is the smallest state in the nation, and it's hard to get comparisons of job descriptions, salaries, and benefits for the same occupation in this state. So we go to our international union and say, okay, we need to have some comparisons for nurses or for snowplow drivers or for correctional officers. And another thing that we have also been known as is because we have the payroll deduction and we're a group, we can offer different member benefit programs to our members at a group rate. Like Delta Dental, we can offer that as a group instead of an individual going out and having to pay the individual plan, which is higher. We have vision, but everybody, it's all voluntary. They can opt into these programs or they cannot. Once they retire from state government, they can continue them as a retired member. And we have the ability to payroll deduct if they're getting a retirement check. And I would hate to think that somebody that has been a member of our organization that is now a retired member for, 40 or 50 years is going to have this pulled out from underneath them. Now, I can also tell you that we've done
Ms.
a lot.
Beardsley,
Yeah.
who do you use for your payroll processing?
The state auditor's office.
The state auditor does all of your payroll processing.
Well, actually, what it is my staff does all the work. So like if you was to be a member, there's the membership dues. And then if you enroll in any of our membership programs, there's a premium. So we add everything together and there's there's actually 4 entries. Their ID number with the state, their name, their agency, and the total amount to be deducted. And we do all of the work on everything. They deduct, they give us our list and 1 check. And then every month we have to break out what is for dues, what is for all of the member benefit programs. And we send that on to the companies as a benefit to our members. But I want to give you a couple examples. I'm going to date myself. I have worked for the association for 51 years. And I didn't start as the executive director, but so I've got a lot of good community stories. And just to give you an example, Senator Mike Enzi was the senator that pushed the needle stick legislation through. And what the needle stick legislation
Hold
was.
on just 1 second. I think we have a question. Senator Kolb?
Yeah, Mr. Chairman, thank you. Could you clarify, are you for or against this bill?
I'm against it.
Okay, thank you.
Oh, okay. I don't want to lose the payroll deduction for our members, but we represent almost all occupations that would be like you talked about the firefighters, you talked about teachers and the other unions, labor unions that, you know, the cops, we represent Wyoming Highway Patrol. We, security in the Capitol building. I mean, these are all people that we try to help and voice, but we're more of a customer service organization. And we try to do helpful things in the communities. And we've tried to provide, like I said, a group rate for anybody that, you know, doesn't have the insurance programs through their employer.
Ms. Beardsley, do you know what percentage of state employees are members of your organization?
The active state employees, we have about 28%.
Active?
Active, yeah, but we've got a very, very huge retirement because the state population, as you probably know, over the last 5 to 7 years, at least a third of the workforce was eligible for retirement. And so members, or state employees have been retiring. And if they were a member of our organization, they could continue any programs they had with us after retirement at the same rate.
Any other questions for Ms. Beardsley? We are at time.
Oh, I'm sorry. I took everybody's time. Sorry.
You just did a slight filibuster there. But Mr. Reddy, I'll give you just a couple of minutes if you'd like to speak, please.
Thank you, Mr. Chairman. My name is Kevin Reddy. I'm the president of the Federated Firefighters of Wyoming. I represent the majority of the career firefighters across the state. And we do appreciate being carved out of this bill, but I would like to remind the committee, Wyoming is a right-to-work state going back to 1963. So mandatory association with the union is illegal in the state of Wyoming. It was reaffirmed by Janus versus ASME in 2018, and it went national that no one can be forced to join a public sector union. And with that, public sector unions cannot apply fees to their members for union services, but they're mandated to provide the fees. With that, if you don't have mandatory affiliation with the union, you can't force people to pay dues. These dues deductions are coming from the paychecks and the wages earned by the public employee. Likewise with PAC funds, charitable contributions, or any other activity that the union has payroll deduction for, it's all voluntary. And to address the political reporting requirements, those are already set out in the Secretary of State's office through PAC fund reporting requirements. So if someone's interested in the political activities of the firefighters, we make our reports similar to political candidates, political parties, and other political groups. With that, I'll stand for any questions. Thank you.
Mr. Reddy, I just wanted to, we had this discussion before we came to this meeting, but I just wanted to clear this up because you did send an email to the body. I don't know if it went to the representatives, but I know it went to the senators. And it referenced that you thought maybe the law only applied to to firefighters under contract?
Yeah, so, through Mr. Chairman, we are concerned because we do represent firefighters that aren't bound, by a collective labor agreement. They don't have a contract with their employer, but they still use paycheck deduction, through an agreement with their employer. Again, no employer is bound to offer paycheck deduction. These are done by employer. Where I work, my mayor has come out publicly and said he opposes the bill. He likes the idea of being able to offer a benefit to the employees as part of the employment agreement.
Any other questions for Mr. Reddy? All right. If I was you, I would have just hidden the back. You're already excluded in the bill. Now you drew attention to yourself. All right, so that is all the time that we have for opposition on this bill. So I do apologize to anyone in the room who would have liked to have testified. Unfortunately, we only have so much time. Same to my folks online. We are out of time for opposition, but we will move to testimony in favor of this bill. We'll start over here on my left.
Hey, thank you, Mr. Chairman. My name is Tyler Lindholm. I am the State Director for Americans for Prosperity right here in the Cowboy State. I wanted to give a big thanks to the representative for sponsoring this legislation. We're on and in favor of it, just based on the simple predication that the state shouldn't be involved in anything to do with private associations, private unions, or anything like that. And this takes them out of that scenario. There's a concern, I think, as far as simple things that are being paid for by the state or by political subdivisions of the state, such as bank transfer fees. That is a thing. It absolutely is. Every time dues are transferred, the state is picking up that cost, or a political subdivision of the state are picking up that cost. And I'll be brief so I don't filibuster, Mr. Chairman, on in favor of the legislation.
Senator Craigo.
Thanks, Mr. Chairman. So, Mr. Lindholm, thanks for being here. Quick question. I mean, I think as I look at this bill, the first first substantive page, page 2 is really in my mind, the heart of the bill, right? We're talking about preventing transfers, but then we spend the remaining, however many, another 7 pages going what I feel is maybe down a slippery slope. And I really like page 2, but the rest of it, I think, causes a lot of the questions or consternation where you're hearing from the rest of the committee and probably from folks out in the gallery as well. I mean, how do you feel about let's just say you can't use automatic transfers and be done with it? Then we don't have all of these other issues. Can you opine on that?
Mr. Lindholm?
Yeah, thank you, Mr. Chairman. To Senator Craigo's question, I think it is a good question. When we're talking about the latter half of the legislation, when we're specifically looking at this report, I mean, really the report is for the members. I have friends and family that are involved in multiple of these organizations that when presented with the fact, hey, did you know that national group of this organization is actually supporting someone that I know you would never support? That's a big deal for them, and they were pretty shocked. So, having a little daylight on this when it comes down to the public, I think is a good thing.
Senator Hicks.
Mr. Chairman, Mr. Lindholm, are you aware anywhere else in statutes where we require private or other public entities to report back to their members?
Mr. Lindholm?
Mr. Chairman, I think that's a good question to the senator's question as far as reporting back where those political donations are going would be the
Senator Hicks.
Yeah, Mr. Chairman, aren't most of those filed on some either federal or state report already and available?
Mr. Lindholm?
Yeah, thank you, Mr. Chairman. To the senator's question, yes, the Wyoming Secretary of State's.
All right, thank you.
Yep.
Any other questions for Mr. Lindholm? All right, thank you.
Thank you, Mr. Chairman.
Sir?
Thank you, sir. Mr. Chairman, members of the committee, my name is John Kalb, and I'm Vice President of the National Right to Work Committee here today to speak in favor of House Bill 178. Basically government employee labor unions are or private organizations that exist for private benefit. In fact, that private benefit often runs counter to taxpayer interest and even many of the workers they claim to represent. As such, it's wrong to use public resources to collect money to finance them. Union officials tend to like payroll deductions of union dues because it saves them the trouble of having to collect dues themselves, while workers never see the money actually hit their bank account. But it's really just a special perk for the union bosses that serves no public purpose. So, just for that reason, and just to answer Senator Crumb's question, I guess, about, sort of dividing out the sort of the union dues from any, contribution to a union affiliated political action committee. The Janus decision in 2018 found that basically all public employee union activity is inherently political. I mean, they're advocating for expenditure of public money, essentially, when they go and advocate for a raise, when they go to the people's elected representatives and say, we want a raise, or we want a new fire truck, or whatever. Obviously firefighters, as we've heard, are carved out, but in any event, or whatever, they're engaging in political activity. And furthermore, union officials tend to engage in other activity that would generally be considered political, aside from sort of their direct political action committee contributions, things like nonpartisan voter registration drives, or any number of internal member communications that, are exempted from having to be under PACs. So anyway, with that, I'll conclude my testimony, understanding I've got some people behind me.
Mr. Kalb, how do you square, let's say we adopt the proposition that we should not allow for payroll deductions for unions, but we're going to allow it for insurance companies. How do you square that? Why should we allow insurance companies to take deductions from public payroll but not associations?
Well, so you're typically talking, in those cases, and thank you for the questions, Chairman Olson. But, in those cases, you're typically talking about essentially things that are sort of, core parts of an employee's being an employee. I mean, one typically gets one's health insurance through the employer. And so, my health insurance and, my life insurance would go out through my long-term disability for, that my employer covers, would go out through a payroll deduction. I mean, the difference between the union dues is that's not sort of a core part of your function at the job. And again, it does run counter to taxpayer interest. And it's, a private organization that exists for private benefit.
Well, and just to add on to that, I mean, insurance companies hire lobbyists. I run into them every day. How is that any different?
I mean, anyone can hire a lobbyist. I mean, I guess from my perspective, it's, when I look at working at a job, the insurance benefit is part and parcel. I mean, obviously the insurance industry is a huge lobbyist. I mean, they're all, local governments tend to be huge lobbyists. Everyone has a right to sort of show up and testify at a committee hearing. Everyone has a right. And I mean, this doesn't do anything about union officials' right. But again, it just when it runs directly counter to taxpayer interest, which, public employee union activity, often does, I think that there's a bit of a distinction there.
Any other questions for Mr. Kolb? All right. No, thank you.
Have a great day.
You're next.
Thank you, Chairman Olson, members of the committee. My name is Patricia McCoy, and I'm here to speak on behalf of the Moms for Liberty chapters across the state of Wyoming. We're here in strong support of House Bill 178. Wyoming taxpayers are getting hit from all sides in a rigged game they didn't sign up for. Right now, our public schools and other government entities funded entirely by hardworking taxpayer money are acting as free collection agencies for union dues and political funds. These automatic payroll deductions take money straight from publicly funded employee paychecks to private labor organizations and their political arms, all using taxpayer funds. And those funds are substantial enough that they can turn it around and weaponize it against the very state that facilitated the collection. We've seen it played out time and time again. Lawsuits against the state of Wyoming over education policies, funding battles, and more. One union alone has dragged the state into court repeatedly. Taxpayers foot the bill for the payroll that pays the dues. They foot the bill for the payroll system that collects the dues. And then they pay again to fight the lawsuits those dues fund. How is that fair? It's like cutting your nose off in spite of your face. The point isn't whether you agree or disagree with any of these unions' agendas. The point is the blatant abuse of public resources. Why should government payroll systems double as funding machines for private political warfare? This bill does not prohibit union membership. It does not prevent any employee from financially supporting any organization. It simply makes them handle their own finances like every other private entity. Pay your dues directly if you want. Don't make taxpayers subsidize the process. Rejecting this bill means endorsing a system that punishes Wyoming families twice over, once to collect and once again to defend it. That's not conservative governance. That's complicity in a taxpayer-funded farce. House Bill 178 draws a clear, principled line: public dollars for public purposes, period. It protects trust in government and ensures accountability. For the sake of Wyoming's families and fiscal sanity, we urge you to support House Bill 178. Thank you.
Questions for Ms. McCoy? Senator Crum.
Thank you. Really good testimony. I appreciate it. Mr. Chairman, my question would be not in favor of any public money supporting the withdrawal funds. And so would you be in favor of excluding, with that, it sounds like the firefighters have an exception, excluding other safety officers, other public type entities from paying the dues and the bills too from this bill, this bill?
Ms. McCoy.
Thank you, Mr. Chairman.
Thank you, Chairman Olson, and thank you, Senator Crum, for that question. I assume you're discussing like the police officers, EMTs, is that correct?
Senator Crum.
Anybody, whether it's police, whoever, but the exclusion, it sounds like, of firefighters.
Ms. McCoy.
Thank you, Chairman Olson. Thank you, Senator Crum. It would be my understanding that because they have that caveat already in law, they can't be included, but if you wanted to make it broad and general to apply to everyone, we would be okay with that.
Any other questions for Ms. McCoy? All right, thank you. Welcome back.
Mr. Chairman, members of the committee, thank you so much for having me back. I'm here today representing the Freedom Foundation. Next to me is my colleague with the Freedom Foundation, who you'll hear from in a second. Mr. Chairman, I'm going to be very brief and just spend my time answering questions if that's helpful. Main point I want to make is it is always inappropriate for public employers to act as bill collectors for private and political organizations. It's just not okay. Second, I think that employees always deserve to know where their monies go. I'm in favor of the bill if that's what you were, or if that's what you were just about to ask me. Sorry, Mr. Chairman. And I also want to let you know that as we've discussed at length, this doesn't affect any of the other organizations out there. And fourth, I want to touch on something a previous speaker brought up a few moments ago. As you know, I used to work for a school district. My responsibilities included the office that handled these types of transactions, and there is work. There is a form that's turned in. There is an action and where we put it into the system, withdraw it, steward those funds, remit those funds, stand for audit on those funds. So there is a meaningful investment of time, but I would tell the members of this committee that any amount of time is an inappropriate amount of time. So I just want to be clear that the horrific burden that will be imposed by passing this bill is, as the previous speaker mentioned, literally filling out a 3x5 card with 5 pieces of information. And instead of submitting it to the school or to the employer, you submit it to your bank or you give them credit card information. So, Mr. Chairman, I'm going to conclude my comments there.
Any questions, committee? All right, thank you. Thank you. Sir, welcome.
Good afternoon, Mr. Chairman, members of the committee. Max Nelson, I'm Director of Research and Government Affairs for the Freedom Foundation. We're a national conservative nonprofit organization, been around for about 35 years, here in strong support of House Bill 178. I'm just answer a few of the technical questions that have come up. I echo the reasons that the other speakers have supported the bill, but I figure it might be the best use of my time to answer some of these technical matters and then wrap things up with any questions you may have. There was a question earlier in the hearing about the penalty. The bill does provide that violations would constitute a misdemeanor. I would just point out that this legislation would be added to the state's right to work law in Title 27, Chapter 7. If you look at Section 115 of that chapter, it provides that any misdemeanor violation in that chapter is punishable by a civil penalty of up to $1,000 and or up to 6 months imprisonment. So this is essentially grafting into the right to work statute's existing enforcement mechanism by stating that violations of these new provisions would be a misdemeanor. But that's the penalty requirement. There was a question about, I think, the financial disclosure component of the bill that requires unions to provide these financial transparency reports to their members on an annual basis and the precedent for that. A little bit of background, the federal government since 1959 has required any union that represents private sector members to file very detailed financial disclosures that are publicly available with the U.S. Department of Labor. You can go pull those off the internet right now. Federal employees, unions representing federal employees have had similar requirements to file these annual financial reports since, I believe, the 1970s. So as the law stands today, the only union employees in the state of Wyoming who do not have access to these kinds of financial transparency reports from their unions are state and local public employees that are represented by a union that's not covered by these federal requirements. So there's essentially the default practice long recognized in a labor relations context is that because of the unique relationship between unions and their members and the fiduciary obligations, if you will, that a union has towards its members, that it's important for the members to have a legal right to see how their dues money is being spent. So unless the state of Wyoming acts to essentially close that loophole for unions that only represent state and local government employees in Wyoming and are not covered by those requirements, then those types of employees do not have that same level of financial transparency as their federal or private sector counterparts. There were some questions about the first responder exemptions for collective bargaining, and I think this ties into as well the argument that we've heard that somehow this is singling out organizations for some kind of disfavored treatment. And I think that's fundamentally the wrong way to look at this issue for a couple of reasons. As the chairman noted earlier in the hearing.
Absolutely, Senator Hicks.
Policy on people filming inside committee meetings. Mr. Chairman,
We do.
We've got somebody in the audience that's actually recording, filming the witness. I'd just like to bring that to your attention.
Thank you. I'm sorry that I missed that. Yeah, if you, we do have a policy in the Capitol against that. So if it happens again, you'll be asked to leave. And that's actually time.
Happy to answer any questions you may have. Thank you.
All right. Any questions for Mr. Nelson? Thank you, Mr. Nelson. All right. So that is going to be the conclusion of public comment. I know there's still some folks in the room and folks online who wanted to testify on this bill, but unfortunately that is all the time that I can allot to public comment. So I will close public comment on House Bill 178. And committee, what is your pleasure? Okay, it's been moved by Senator Kolb and seconded by Senator Hicks. Are there any amendments to this bill? Senator Kolb?
Yeah, Mr. Chairman, I guess I can't see the real purpose of going beyond page 2. And maybe we have to work on that a little bit, but I don't know. I think if people are going to opt out or to say they don't participate with a government deduction system, I don't know what dog we have in the fight on these other reporting requirements, because you can send your money in, and when you do it, why are we getting involved with that, with knowing these other things? I guess that's my global question on what the rest of this is needed for. I think if we say you don't get we wouldn't be involved with these deductions using state resources, fine. But why would I guess that would be my proposed amendment is why do we go beyond page 2? And I'd like to hear, I guess, a discussion about the need.
Senator Craigo, did you have some discussion on that? I do as well, but
Yeah, Mr. Chairman. So I'm fine with that idea. I brought it up earlier, but I think there are some things at the end
Yeah,
that we have to include to clean some other stuff up.
Are we only talking about section 1? We're not talking about deleting section 2.
Correct, but I also think, Mr. Chairman, I don't know if, and this is up for discussion, but on page 6, subsection G, the nothing in this section shall be construed to. I don't know if we want to include that language or if it's necessary, but think it probably is. I mean, we need, for example, on page 7, Romanet 6, we want to make clear that we're not prohibiting a public employee from paying dues, fees, contributions, or other charges directly to their labor organization. I think one of the sponsors out here has something to say.
Senator Bonner?
Yeah, just real quick, as that discussion evolved, I think maybe sections B, C, and D would be the reporting requirements. So if that's what the committee wants to discuss, I think those would be the relevant paragraphs. I wouldn't just delete everything after page 2. That's, so that's not accurate that somehow everything after page 2 is all reporting.
So B, C, D, E, and then you're suggesting to keep F?
Well, and maybe even E if that's a penalty.
And keep E? Senator Craigo?
Yeah, Mr. Chairman. So the penalty's already in statute. I looked that up. So you don't need that.
Probably a general provision that says any violation of this title.
Yeah, we're going to have to amend that. It's section 115, and we're going to have to amend that to include section 116, which is the new section we're creating, but I'll get to that in a bit.
Okay. So sounds like we don't need subsection E then in that scenario. Subsection F is any person may file a complaint alleging a violation of this section with the Attorney General.
Mr. Chairman, I think you can get rid of that section.
Get rid of F.
Yep.
And then keep G on page 6.
Correct.
And then that brings us to the end of section 1. So that is Senator Kolb's amendment? Or
It is, Mr. Chairman, I'll say it. I meant it globally to everything past that point, to have a discussion about the relevance that's needed. And that's where we're at. So yes, that's my amendment, Mr. Chairman.
Pierre, does that make sense?
Yeah, so we would get rid of section B, C, D, and E, and F.
Sure.
We keep subsection G.
Yes.
Keep section 2, 3, 4, and 5.
Correct. That is the amendment. Is there a second to that amendment?
Second.
Seconded by Senator Hicks. Any other discussion? All those in favor signify by saying aye.
Aye.
Any opposed? All right, that amendment has been adopted. Sounds like there are some other amendments that we need to make this work. Senator Craigo?
So, Mr. Chairman, and I'll tackle the first section 3, which is a repealer of 108A and B. And I'm not sure why we're doing that because there seems to be some pretty pertinent definitions in there. Now, the subsection A is brought back in on C1, Romanet 1. That is the definition. Labor organization is the definition of 108A. But B is the definition of person, which person is outlined within the criminal enforcement provision. So I'm not sure why we're taking out B. And I would say it's probably a drafting error. I don't think we would want to take out the definition of person. Otherwise, we won't be able to, because person is defined as, I'll read it to you, Mr. Chairman. The term person shall include a corporation, association, company, firm, or labor organization, as well as a natural person. Seems like the whole point of the bill is to be able to apply a criminal, penalty to the labor organization if they're doing something they're not supposed to be doing. So I'm not sure why we're taking that out. Seems like we probably would not want to. So I also don't think we need A. I think we just need to renumber this. I would suggest we delete section 3, the repealer.
Delete the repealer. Okay. So motion, and it's been moved by Senator Craigo and seconded by Senator Hicks to remove section 3. Any discussion on this amendment? All those in favor signify by saying aye.
Aye.
Any opposed? All right. Additional amendments, Senator Craigo, the penalty provision.
So the penalty provision, we're going to have to add that in, Mr. Chairman. So that is section 27.7.115. And we'll just have to add that in and pull that in from statute. And to amend that, we're going to have to include section 116 within that statute because it's specifically defined there.
Okay, so the amendment is to add 27-7-116 to the list of statutes in 27-7-115.
Correct.
And is there a second?
Second.
It's been seconded by Senator Cole. Pierre, you got that? Yep, you got it.
And
Any
then,
discussion?
oh, go ahead. We got one more cleanup. So
Okay,
page 7, I think we can strike lines 19 through 23. And strike lines 1 through 3 on page 8. And then I think we make public employee subparagraph C. So within section 108.
explain to me why you're deleting labor organization
Because it's already defined.
in the statute?
Yeah, because we pulled out the repealer, so it's already defined.
Oh, okay. That was the repealer.
Yep.
Gotcha. Okay.
It would become C.
And then renumber.
Right. So we're striking paragraph on page 7. We're getting rid of that.
Romanet
C.
I. No, you're keeping the C
Well, you
as
can-
used in this act.
It would become C.
Yeah, okay.
Because this is gonna move up. Public employee becomes C and
Wouldn't
public
it just be-
employer becomes D.
Wouldn't it just be as used in this act, Romanet 1 and Romanet 2?
No,
No?
You already have A and B.
because you already have A and B, and so that would not work.
Oh, okay.
Do C and D.
Okay.
My co-counsel over here, we've been working on this for
All
a
right.
while.
You guys. All right, I'll trust you. Okay. Pierre, does that make sense?
Yes.
And then we can strike 15 and 16 because that's no longer necessary.
Lines 15 and 16. Okay, is there a second on this motion? Okay, it's been seconded by Senator Crum. Any discussion?
Mr. Chairman,
Yes, Senator Crum.
after all of that, who does this bill apply to? Does it apply to the original folks, or is it a broader bill now that applies to everybody outside of the firefighters?
Senator Crum, we did not change the definition of public employee, which has the exclusion of public safety agencies. So the bill still will not apply to public safety agencies, fire department, police, E EMS.
Mr. Chairman, I would move that this bill.
Well, we got a motion on the
We
on the floor right now.
we have-
Why don't you
we got-
save that motion?
Okay,
Let's dispense with this motion first. Any other discussion on this amendment? All right, all those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment has been adopted. Senator Crum, now you may
thank
make a
you, Mr.
further
Chairman.
motion.
I'd make a motion to reword that, and maybe I can get some help from folks down the table here, that this would apply to all public employees outside of firefighters. To make it fair. I mean, I just don't see how you can segregate some groups and not bring in others.
Yeah, so it sounds like your motion would be on page 8, line 10, delete public, and then delete lines 11 through 13.
Yes.
Is there a second for that?
Second for discussion.
Okay, seconded by Senator Crago. Discussion. Senator Kolb.
Yeah, thank you, Mr. Chairman. How does that fit on the bill title? That specifies public employee unions. Does it have any effect with that? Is it still within the scope? That'd be my question.
I mean, the title is prohibiting public employers and specified organizations from automatic deductions or dues. So I would say it does fit within the title.
That was my only concern.
I think it's a policy question. Any other discussion? All those in favor signify by saying aye.
Aye.
Those opposed?
No.
Okay, that motion is I'm confused. Cause I didn't hear everybody.
I'm still thinking.
You're still thinking?
Yeah. Well,
Okay.
you didn't vote either, Mr. Chairman.
Yeah, we had two.
You must be thinking as well.
Take the motion and start over. Mr.
All right, let's start over. The motion is on page 8 to delete line 10 public and lines 11 through 13 so that this bill applies to all public employees. All public employers, excuse me.
So, Mr. Chairman, just to be clear, that's not gonna take care of the firefighters, because they'll still have the exemption built on page 6.
Yes.
But just to make clear, I mean, we're talking about every other public employer except firefighters who have the other carve out in Title 27. But
You wanted to include that in your motion? Would you?
If that needs to be in the motion, then yes, not to include firefighters.
Okay, we will conceptually include that for now. Let us see if we even pass this thing before we worry too much about what it looks like.
point of clarification, Mr. Chairman.
Senator Craig.
So are we adding the amendment in on page 6 or are we
Yes.
just talking on page 8?
No, I think Senator Crum wants to add the amendment on page 6 to exclude firefighters from the exclusion. To include firefighters in the definition of public employer.
Firefighters, Mr. Chairman.
Senator
My
Crum,
motion would be to include everybody with the exception of firefighters, which are excluded under another section.
does everyone understand the motion this time?
So where are we putting this in?
Well, I don't want, but let's conceptually understand what we're doing. And then we can figure out how it fits in the bill, but just conceptually, it's gonna apply to everybody.
Except firefighters.
Except firefighters.
Okay, got it.
You ready to vote on this?
Yes.
All those in favor signify by saying aye.
Aye.
Those opposed? No. Those in-
I'll add no to it then.
Okay, those in favor, raise your hand. Those opposed, raise your hand. That amendment has failed. Okay, are there any other amendments to this bill? Think we've. Just remember when you send a bill to Senate Judiciary, what happens to it, Senator Boner and Representative Williams? All right. With that, Pierre, will you do a roll call vote on House Bill 178?
This is a roll call vote on House Bill 178. Senator Craigle,
Aye.
Senator Crum,
No.
Senator Higgs,
Aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 no.
2:03, we are adjourned.